It is in this vein that this constitutional proposal is made to give dispensation to a judge of a high court who has been elevated to the Court of Appeal to continue to sit as a judge in order to conclude part-head criminal matter, given the advantages it gives to our judicial system. Since this is a constitutional alteration, the supreme fate which befalls Section 396 sub 7 of the Act occasioned by the Supreme Court will not befall this constitutional provision when passed into law. And the objectives are: the bill seeks to amend the Principal Act to allow a judge elevated to the Court of Appeal to continue hearing criminal matter part-head by him before his elevation.
The issue at stake is that of conflict of interest. How does a judge in good conscience preside over a matter which he had in the lower court and then sit on appeal on that same matter that he presided over at the lower court? There will be a fundamental conflict of interest here.
Speaker, may I say categorically that there is no conflict of interest here and there can never be any. We have always been complaining as a practitioner in legal practice that our justice is often too delayed. And my lord, when justice is delayed, it is equivalent to justice denied. Mr. Speaker, the moment a judge presides over a matter, a part-head matter, in most cases, criminal matter takes 3, 4, 6 months, 1 year, 2 years. And you now ask that judge, maybe just remain one witness or just a judgment to be delivered because he moved to Court of Appeal. In most cases, when a judge, for example, is appointed in Bayelsa State, he will always be transferred to a different jurisdictions. And even if it's within his jurisdiction, all he needs to do is to excuse himself from the matter when he goes to appeal. There can never be any conflict. If we don't allow this bill to scale through, we will be killing exactly what we are trying to build. People are shouting outside.
Speaker, part of the problem we have is slow dispensation of justice, particularly criminal justice. Part of the reason why people don't even go to court is that a criminal matter may linger in court for 7 years and above. In some cases, people in awaiting trial leads to prison congestion. So his mind was actually to decongest or bring a fast dispensation of criminal justice. A case in mind is the case of Senator Auditor Carlo and EFCC. This is the purport. I think this captures that scenario in that matter. The ratio decisis in that matter, where he went upstairs and came downstairs to still speak. The worry of those who are attacking this bill is, can you speak from up and down? But I think that anything we can do to get fast dispensation of criminal justice will achieve a lot for Nigeria.
I will say that it will have been better to say, at least let's give the judge who have been elevated to the higher court a period of, say, 3 months to clear his table before he assumed the new office. If that is done, we have been able to clear the matter. But if you allow a situation where the judge who is presiding at the lower court will be the same person that will preside at the higher court, even if it is not specified that he is the one, some judges will still insist to find a way of presiding still at that level. And that could be, and if you are in trouble, since it's a criminal matter, and the man is determined to lock you up, you will get locked up even at the upper level.
Instagram.